Hi, and welcome back to Roots Tech 2025. Our presenter is Dr. Nicholas Dixon. He's a professional genealogist and historical researcher in London, United Kingdom. He studied history at the universities of Oxford and Cambridge and was awarded a PhD in history degree by the University of Cambridge for a thesis concerning the Church of England during the early 19th century. He has also been awarded a postgraduate diploma in genealogical, paleographic, and heraldic studies with distinction from the University of Strathclyde. He is an external contributor to the History of Parliament project, and he undertakes research for clients whose ancestors lived in the United Kingdom, including international clients. He is a director of the Register of Qualified Genealogists and a representative for the Britain, Ireland, and the Isles chapter of the Association of Professional Genealogists. His areas of genealogical expertise include maritime records, legal disputes regarding inheritance and property, house history, church records, families in London, and links to the British monarchy. And he'll be talking to us today about using deeds and civil court records to trace your British ancestors. Dr. Dixon, thank you.
Thank you very much for your introduction. Before I begin my presentation, I will just give a brief I will like to request you to please silence all electronic devices and also advise you that there should be no audio or video recording and no photos of this presentation. Thank you very much to Family Search for inviting me to speak to you at RootsTech. In the next 45 minutes or so, I'm going to talk about what is generally considered one of the most difficult aspects of British genealogical research, which is the use of deeds and civil court records, such as those of Chancery and the Court of Common Pleas, to trace our family history. I'm going to be focusing on the records which relate to England and Wales, but I'm also going to touch on the records of this kind that are available in Scotland as well. Now, the vast majority of the records that I'm going to be discussing are not digitized. So you won't find most of them on websites like Ancestry, Find My Past, or Family Search. And I think it's quite unlikely that they're going to be there in anything like the foreseeable future, because the physical properties and the volume of the records that I'm going to be talking about make it highly unlikely that anyone will attempt to digitize them to any very complete degree. So in order to access deeds and civil court records relating to England and Wales, I think it's fair to say that you have three main options. Firstly, if possible, you can visit an archive in person and look at the records there. Secondly, you can employ a professional genealogist to do this on your behalf. And thirdly, if there are records that seem to be relevant that you find in an online catalogue, and many online catalogues for British archives are incredibly detailed, thankfully, you can ask the archive in question to send you digital copies of these documents, which often they are willing to do, but usually for a fee. Now, in this age of widespread digitization and DNA, I think that there's something old-fashioned and charming about a type of genealogical research that still can't really be done online and requires a knowledge of archaic legal terms and some Latin. Although most of the documents used in this research are no longer actually used by lawyers today, at one time, deeds and chancery records were really the bread and butter of solicitors and legal clerks. And those of you who have read Charles Dickens's Victorian novel Bleak House, which was published in the 1850s, will be aware of the popular caricature of the Court of Chancery, one of the courts that I'm going to be talking about today. And that caricature is one of endless and confusing civil lawsuits like Jarndyce and Jarndyce. And those like me who use the contemporary indexes of Chancery records, which are held at the National Archives in London, and these have never really been replaced or digitized, and they go back to the 16th century, those of us who use those records must feel, at least sometimes, transported back to the 19th century. And so in order to use the records, we need somehow to think ourselves back into the world of the Victorian lawyer or clerk, how they classified and indexed things, the terms that they used, and not least, the way that they arranged the records. Now, most archives have, for very good reason, retained the original arrangement of deeds and legal records in their collections, and they're often found tied together in bundles with scraps of paper denoting the parties or the land which was involved. So we mustn't expect to find things indexed or searchable in what we would consider a modern way, even where the records have been extensively catalogued. It's worth bearing in mind, although it's a very obvious point, that these records were simply not created for genealogists. But as I'm going to demonstrate in this talk, the rewards of finding an ancestor in these records are great, sometimes much greater than finding them in the digitized records with which we're all more familiar. So, as with all of genealogical research, it's really worth persevering. Now, in the first part of my talk, I'm going to discuss deeds. So, what do I mean by deeds in this context? Well, any of you who have purchased any property or taken out a mortgage will know that this involves legal formalities. And nowadays, in England and Wales, these are greatly simplified from what they were in the past. Most houses in England and Wales are now sold by means of a simple conveyance, an exchange of contracts accompanied by a new entry in His Majesty's Land Registry. But in the distant past, things were not so simple. The documents drawn up by the lawyers for buying, selling, and mortgaging land were long and elaborate, and often in several connected parts. And I'm now going to explain the main types of these documents and also indicate when you might find an ancestor mentioned in them. And in order to do this, it's necessary to go back to the medieval period when we find the earliest deeds in archives. From the 12th century to the 15th century, the main type of deed for conveying land was called a deed of gift. And this term implies that the land was being given freely. And indeed, in this type of deed, no actual payment is actually recorded. But in reality, this type of deed was used for sales of land as well as for actual grants of land. There is often a difference between the perception and reality with deeds, as I will show. And a deed of gift will name two or more parties, and there is a crucial phrase in it in Latin which states that the person giving the land gives, grants, and by the present charter confirms their gift. And the feftment is another common type of medieval deed. It's very similar to the deed of gift, except that unlike the deed of gift, it acknowledges that the conveyance is for a sum of money. And then there are quit claims, which were deeds drawn up to ensure that no one claimed land after it was sold, and letters patent, which were grants of land by the monarch recorded in the patent rolls. Of course, relatively few of us can trace our ancestry back to the time when these deeds were used, but it's not impossible that a connection can be made with parties in such a deed, especially where an unusual surname and a small place are concerned. Now, after a law of 1535, called the Statute of Enrolments, we find that the bargain and sale becomes the most common form of deed in England and Wales. And this is perhaps the classical form of the English deed, from which most of the others that I'm going to discuss derive. The bargain and sale was written on a large piece of parchment, and the parchments used for these purposes were indented to signify that there was a unique duplicate of the deed. And this gives us the word indenture, which we see at the beginning of so many deeds, including the lease, which is shown in this slide from the 17th century. And the term indenture becomes a term which is used to refer to any type of deed in which two copies were made. And in theory, both parties could bring the two deeds together, and the way in which the deeds were cut would prove that they were part of the same transaction originally. So it was really a means of verification and perhaps a safeguard against forgery. So these deeds, unlike the medieval ones, were always in English, and they contained the names and details of the parties involved, and they include the crucial phrase granted, bargained, and sold, as well as the precise consideration, which is a term used for sums of money paid by the buyer to the seller. And there was also a description of the location and the features of the property sold, which always comes after the words all that. So although these documents are very long, if you start to look at a large number of them, you can see the formulas that are involved and look out for where the crucial information might be found that will tell you something about your ancestors, hopefully. Now, bargains and sales were enrolled in the Court of Chancery, so that meant that an official copy was kept, and they can be found in the close rolls, which are kept at the National Archives, as well as in local archives. And in theory, that should have meant that England and Wales should have had a complete record or registry of deeds to a certain degree. But the English legal profession had other ideas. They and their clients didn't like having to enroll deeds. They wanted these transactions to be more private. So they found an ingenious way around this, which was the lease and release. However, it's worth noting that deed registries did exist for the county of Middlesex, which covered much of what is now the London area, and also in Yorkshire. So if you have ancestors from there, it's certainly worth looking into those deed registries. Now, the lease and release, which essentially replaced the bargain and sale to a large degree, is the standard deed used in England from the 17th to the 19th centuries. But it's far from straightforward, and like many deeds, it can be really quite deceptive. It consists of two documents. The first is a lease of a property for a short time, and the second is a release of the exact same property by the owner to the person to whom it was originally leased. And the lease is a very short and small document. If you're looking at these documents in an archive, you'll often find it tucked inside the larger release. The release is much larger, and it might be considered rather long-winded, using much of the same phraseology as the bargain and sale that it was invented to replace. And for us as genealogists, the crucial parts of the document to look at will usually be the parties named, and here we often have the occupation and the place of residence, as well as a statement of how people actually related to each other, which of course is really vital information if you're tracing your ancestors before a certain point, especially if there are gaps in the parish registers. And you'll also find a description of the property, which often gives the tenants, both present and past, with the phrase in the occupation of, and then those people are named. These are often large, unwieldy documents, but they contain some very useful information. And of course, you can also find leases without releases, where a property is simply leased to a tenant. And there are also other documents of the same appearance and period that are worth noting in passing here. There are marriage settlements which were drawn up in advance for wedding to convey property to trustees, who would then set it aside for the use of the married couple and perhaps for their heirs as well. And these provide vital corroborative evidence to the marriage entries in the parish registers, which can be lacking or uninformative before the introduction of standardized marriage registers in the 1750s. And then there are mortgages. So when you come across a mortgage from before the Victorian period, so really before 1837, try to forget everything you thought that you knew about mortgages. Because before the 19th century, people didn't take out a mortgage before buying a house or plot for the most part. Rather, they mortgaged property that they already owned in order to obtain a loan in which the property was a security. And so the mortgages before a certain point really resemble the leases and releases that I've been talking about. And when you start reading them in an archive, they seem initially to be an actual sale of the property to the person who is lending the mortgage. But there is always a crucial clause that says basically that everything is null and void if the loan is repaid. And in reality, a foreclosure on an unpaid mortgage was extremely rare before a certain point because the owner had something called the equity of redemption. And this entitled them to hold on to the property until legal proceedings against them were concluded. And you'll often see when you're looking at these kind of deeds that the mortgages reassigned from one lender to another. Mortgages are reassigned from one lender to another many times while the actual owner remains the same. So they can be quite confusing. Mortgages are, however, very interesting because lots of people are named in them. So if you're looking for ancestors in the 18th century in England, it's just as likely that you'll find an ancestor lending money in a mortgage as actually owning the land. So they certainly shouldn't be overlooked. And after 1845, everything is greatly simplified because a law replaced the lease and release deeds with a simple release, which became known as the conveyance, which is quite similar to the type of legal document which is still used for these purposes in England and Wales today. And eventually we do see modern mortgages in which a bank lends money to someone to enable them to make a purchase. But to illustrate what I've just been talking about in the abstract, I'm going to discuss some more deeds in a particular case study. And this concerns land holdings in Surrey, the county just south of London, part of which is now incorporated into London. And to demonstrate that it is possible to find ancestors in these records and that they can further genealogical research, I'm going to discuss some deeds in the Surrey History Centre in Woking that relate to branches of my family who lived in the west of Surrey in the 18th and 19th centuries. And in this map, you can see a map of Surrey from around the 1840s and various rather idealized scenes of what it looked like. And so to begin with this, my 6 times great-grandfather was a farmer named Richard Roke. And he was baptized in a riverside town by the Thames called Chertsey in 1763. His uncle was a man named James Roke, who was a wheelwright in Putney, which was then in Surrey, but is now in London. And this James Roke was the owner of a public house or pub in Horsell, close to Woking, which was called the Wheatsheaf. And in fact, this particular pub is still there, although it's been rebuilt. And from deeds in the Surrey History Centre, which is the county archives for Surrey, it's possible to trace back this very property to 1686, when it was leased by Denzil Onslow to a farmer named John Hone for 1,000 years. And by a deed of gift, which was dated 1717, a very late instance of deeds of gift, John Hone gave 2 cottages with gardens and outyards to his son, who was also named John Hone. And in 1734, John Hone Jr. assigned the lease of the property to Charles Barefoot, who was a husbandman, that's a type of farmer, of Chertsey. And Barefoot then assigned the lease to John Lipscomb, who was a carpenter of Horsell in 1737. And Lipscomb's will, in which he bequeathed the property to his daughter Anne for her life and afterwards to his son James, and made other bequests to his children, was proved in 1768. And there is a note attached to a copy of this will which states that Joseph Roke, the brother of James Roke, had stated that John Underwood, Lipscomb's son-in-law, had received a legacy. And in 1772, James Lipscomb mortgaged the property to William Brooker, plumber of Chertsey. And the following year, he made an agreement with James Roke, who I mentioned, to sell the property, which was, as the deed said, now called by the name of the Wheatsheaf. And one of the tenants was Joseph Roke. The mortgage was then paid off by James Roke. The receipt is among the records, and the lease was reassigned again. James Roke didn't marry, and on his death in 1785, administration was granted by the Prerogative Court of Canterbury to his nephews Joseph, John, and Richard Roke, who is Richard Roke being my direct ancestor. And these 3 men then assigned the lease to another Roke, who was probably a more distant relation, called Henry Roke, who was a yeoman farmer in Woking. And this Henry Roke mortgaged the property to Henry Vincent, a yeoman of Chobham, in 1786. And that takes us to a century after the original lease of 1686. Part of the land later became a nursery. And from this very complex set of deeds and succession of transactions, you will see that the history of a piece of land is rarely straightforward. It's often necessary to navigate a bewildering succession of deeds and to somehow piece them together. But the advantage of these documents is that numerous individuals, owners, occupiers, mortgagees, legatees, are named. So if you're fortunate, you can assemble sometimes entire family tree from such documents. And in fact, without these deeds, I wouldn't have been aware of the connection between my ancestor and the Wheatsheaf in Horsell, as well as his connection with his uncle, the wheelwright of Putney. And I've also found that the same Richard Roke appears much later, again in a deed from 1824, again held in the County Archives in Surrey. And this time it was a lease by a man named Daniel Lambert of Streatham to my ancestor of a farm in Chertsey. And Richard Roke, my ancestor, died 2 years later. The lease was then reassigned to his son, James Roke. And obviously the legal documents can be somewhat dry and formulaic, but a few years ago, I found Richard Roke's monumental inscription in the churchyard at Chertsey, which I'll briefly read. And it says, "This humble monument will show where lies an honest man. Ye kings whose heads are laid as low, rise higher if you can." And so by combining the deeds which mention Richard Roke to a certain degree with this monumental inscription, I feel that I can see 2 sides of him. Certainly I can learn about his life as a farmer, but also about something of the way that people perceived him after his death and his character, I think. So I think that there's a lot to be gained from looking beyond the standard parish registers and really seeing what other records are available for an ancestor. Now, the first daughter of this Richard Roke was illegitimate, although Richard subsequently married the mother, who was named Sarah Bridger, and she was my ancestor, Elizabeth Roke. And Elizabeth Roke married Thomas Ames, a shoemaker from Dorset, who became the first master of a workhouse in Guildford in the 1830s. And one of their sons, who was also named Thomas Ames, appears in a Guildford deed of 1859. And this is the lease of a property in Guildford's High Street, in which Thomas Ames was not actually a party, but he's mentioned in connection with a right-of-way that passed through a doorway which adjoined, and I quote from the deed, the brewery and cottage now in the occupation of Thomas Ames. And you even have a helpful map showing the location of this property in relation to other plots in and around this lane close to the High Street in Guildford. And this derived from an auction notice for the very same property. And like many of the Victorian deeds, so the deeds that come after the 1830s, it's much smaller than the 17th and 18th century deeds. And by this point, you start to find a lot more detailed plans, which can be invaluable in really locating one's ancestors, where sometimes a census record might be rather more ambiguous. So it's worth noting that deeds can be found not just in the county or local archives like the Surrey History Centre, but also at the National Archives in London, and many are still in private hands, owned by the present owners of the property. So they can be found in all kinds of places. So moving on to the records of civil courts, there's one such court whose records can often be used in conjunction with or instead of deeds, and that's the Court of Common Pleas. And this court sat in Westminster Hall, in the Houses of Parliament, and it issued final concords, which were also known as the Feet of Fines. And these documents were formulaic, and they concerned fictitious legal disputes between two sets of parties concerning a piece of land that was in reality being sold in the usual way. And those who were buying and selling land entered final concords as a kind of backup for the much more complex deeds that formalized the details for land sale. They were known as the Feet of Fines because it was the foot of the fine that was kept by the court, so the bottom part of it. And these records that were kept by the court are in the National Archives. Well, the other two indented copies of the same document were kept by each party to the fine. So in theory, as with the indentures that I've already been talking about, all three parts of the fine could be reassembled. The fines were in Latin from medieval times in the 1730s, and thereafter in English. But despite the fact that they're in Latin, they are not enormously difficult to understand because the same form of words was used continually for centuries. And the most important thing in them is the names of the parties, which are often a husband and wife, and they also give the location of the land. So where the deeds don't actually survive, the surviving fines can provide vital evidence of a property transaction or the ownership of land by an individual or a family. There are contemporary indexes to the Feet of Fines in the National Archives. And for many counties, there are also some published indexes which give names and parishes. And fines will often also be found among larger deed collections, which can include a deed leading to the uses of a fine, which was essentially a deed which was there to define what the fine really meant beyond the legal fiction. And so we come to Chancery, which is perhaps the most difficult, but sometimes the most worthwhile aspect of genealogical research in England and Wales. Susan Moore is the foremost authority on this subject, and I would certainly recommend reading her book on it, which gives a lot of detail about these types of records. But I'm going to give you a brief overview of using Chancery records from my own experience. So, like the Court of Common Pleas, the Court of Chancery also sat in Westminster Hall from the medieval times until the 19th century, although outside of the legal terms, in what were known as the vacations, it could also sit in Lincoln's Inn Hall. And the illustration that's shown in this slide from the early 19th century actually shows it at Lincoln's Inn, also in London. And Chancery had many functions, but perhaps its most important function was to adjudicate in cases involving inheritance and property. And copious records were kept and are kept of these civil cases, which were known as suits. And they're a treasure trove for genealogists. All of the records of Chancery itself are in the National Archives, but you may well find papers concerning lawsuits in local and private archives as well. The records that are kept at the National Archives are extraordinarily varied in terms of the time frame and the content. And to go through it briefly, they consist of bills and answers, which were the complaints submitted to the court by the plaintiff and the responses of the defendant. These are enormous and very detailed documents. We also find order books, which state the orders and decrees which were made by a judge or a master of the court concerning a case. And we find the master's reports, which are very detailed judgments that were, for the most part, that were made by the masters in Chancery, who were the lower judges that were appointed to oversee a case. We also have affidavits and depositions, and these can contain extraordinary degree of detail as well. These are witness statements submitted by the parties in a suit. Then there are exhibits and papers, which were documents used as evidence in a Chancery suit and not afterwards reclaimed. And these can really, in theory, be anything, but often they're deeds, and sometimes you'll find people's correspondence and private papers there. There are also accounts which were kept by a receiver if they're appointed by the Court of Chancery to oversee a particular property. And these, again, are very detailed because they tended to record every single sum of money that was expended in relation to properties and estates. So some of the records that I'm talking about are indexed and searchable on the online catalogue of the National Archives, the Discovery Catalogue as it's known. Especially you'll find the pleadings, exhibits and accounts there. And other Chancery records can be found in the Burnau Card Index, which has been microfilmed and is available through Family Search. But the majority of Chancery papers only have contemporary indexes. Those for the order books are on the open shelves at the National Archives in London, but many of the indexes need to be ordered like any other document, such as those for the master's reports and affidavits. And it can therefore take some days to find all of the papers relating to a case, and a lot of the time speculative searches for particular years are necessary. Chancery cases could sometimes take many years to be resolved, although many were actually resolved quite quickly. It's important not to assume that every suit was like the one portrayed by Dickens in Bleak House. Cases could also be revived after becoming dormant. And the best approach, if you're looking for the details of a Chancery case, is to find the bill for it through the online catalogue and perhaps any exhibits or accounts that relate to it. And then you can search for the relevant orders relating to a case. And then these should hopefully enable you to find some of the other records, such as the affidavits and reports. So in this part of the talk, I'm going to return to my ancestor Richard Roke, the Chertsey farmer who died in 1826. Now, his first wife, Sarah Bridger, who was the mother of my ancestor Elizabeth Roke, died at the age of 23 in 1785. And Richard then married Sarah's sister Elizabeth at a village called West Molesey, which is close to the Thames and close to Chertsey, in 1789. And they had 9 children. The father of Sarah and Elizabeth Bridger was a man named John Bridger, a blacksmith who had married a woman from Woking in 1758 and settled in Chertsey. And she inherited copyhold land, which was held of the lord of the manor in Woking from her father. And after her death, this passed to John Bridger. And in John Bridger's will, which was proved in 1795, John left the copyhold estate to his daughter Elizabeth, who was the wife of Richard Roke, on the condition that £100 from the estate should be paid to his granddaughter Elizabeth, who is the illegitimate daughter of Richard Roke and Sarah Bridger. And in this slide, you can see a contemporaneous illustration of the reading of a will. And it was often the reading of the will that was the event that initiated a chancery suit, such as the one that I'm now describing. So in July 1827, this Elizabeth Roke, the granddaughter, with her husband Thomas Ames, submitted a bill of complaint to the Court of Chancery, which claimed that she hadn't been paid the money left to her in her grandfather's will. And her aunt, Elizabeth Roke's, that's the widow of Richard Roke, her aunt's reply to this bill includes some absolutely fascinating details that would be impossible to find in any other source. And I'll just briefly read a few of these because I think they do give you a good idea of the kind of records that I'm talking about. So it says that soon after their marriage, Thomas Ames went to sea, leaving his said wife at Beminster in Dorsetshire, very destitute. And in or about the month of February 1806, when Elizabeth Ames was lying in of her first child, she made pressing applications to this defendant for money on account of her said legacy. The complainant Thomas Ames returned from sea, and being exceeding poor, he from time to time made pressing applications on account of the said legacy. And when the complainants were residing at Chelsea, there was a time when Elizabeth Ames, the complainant, was ill of a fever. And it also refers to a time in 1812 when the complainants resided at Turnham Green. These are all now places in West London. And the said Thomas Ames wrote to the defendant's husband stating that he could not live and maintain his family any longer where he was, and that he should therefore go into Devonshire where they could live cheaper. And there's also a receipt from Elizabeth Ames, which talks about receiving from her father, Richard Roke, meaning the defendant's husband, the sum of £100 left me by my grandfather, John Bridger of Chertsey, out of the copyhold estate at Woking. And there's also a reference to a fire that broke out in the house of the Rokes at Chertsey in 1826 and entirely consumed it. Now, Elizabeth Roke claimed that legacy had been paid, and the suit actually proceeded no further as far as I can tell. But her testimony tells me many things about Thomas and Elizabeth Ames, and it actually confirms the parentage of Elizabeth Ames, which is not clear from her baptismal entry. And this is why Chancery records are indispensable. But it's not just the bills, which are quite easy to find in the online catalogues, which can produce such information. There's another Chancery case from the 1820s that I've researched because it concerns the stepmother of my ancestor James Flowerday, who was the son-in-law of Elizabeth Ames, marrying her daughter Eliza in 1828. And this suit concerned the maintenance of the children of the stepmother, Anne Hebden, by a previous husband, Thomas Chapman. I found papers concerning this suit in a Chancery Master's documents in the National Archives. And among those documents was an affidavit by Anne Hebden from 1829, in which she states the following about Thomas's surviving brothers, William and John Chapman. She says that the infants had always lived with her since the death of their father and had been maintained by her and William Hebden, who was her husband, in a comfortable and respectable way. She also said that the plaintiff, William Chapman, was discharged about 6 months ago under the Insolvent Debtors Act and has since lived in a public house in Upper Thames Street as the servant of the proprietor for the purpose of keeping it open. Also, that William Chapman was in extremely indigent circumstances and without any visible means of supporting his family, and that the said John Chapman, the other uncle of the said infants, was a bricklayer in very needy circumstances and living in an obscure lodging in Bevis Marks, which was a street in the City of London, and he had also been discharged under the Insolvent Debtors Act. And this case concerned property in Upper Chapman Street, which was in the parish of St George in the east, in the east, what's now the east of London, and the deeds for this property are actually still in the National Archives because they were never reclaimed. And before I leave the topic of Chancery, I will just share one more discovery that I made, in this case about James Flowerday, the stepson of Anne Hebden and the son-in-law of Elizabeth Ames. From insurance records that are held in the archives in London, I was able to find that he and his father had lived at Rosemary Lane in Whitechapel, again in London's East End in the early 19th century. And I also found who the owners of this property were. I searched for the family and for Rosemary Lane in the National Archives catalogue, and I discovered that the property had been the subject of a chancery suit in the 1820s. The property had been given into the hands of a receiver on behalf of an infant who had inherited it. And the accounts, which gave all the tenants and the rents received, were in the National Archives. So, of course, I couldn't resist looking for my ancestor, James Flowerday. And as I was looking at these accounts, everything seemed quite ordinary at first. James and his father were shown paying their rents consistently over a number of years. And then I found something amazing. Suddenly, in 1830, James Flowerday was in arrears, and there was a note in the account book which read as follows: "Ran away and removed his goods in the night, might be recovered if it could be ascertained where he now resides." And to find my ancestor running away from his house in the middle of the night to avoid paying rent was something quite astonishing, a real insight into his life that I never otherwise would have had. Chancery is the richest source of genealogical information among the civil courts, but it's worth noting that there are other such records in the National Archives. The records of the Court of Exchequer, the Court of Star Chamber, and of King's Bench all contain very extensive information about families, though sometimes it can be even harder to find than in Chancery records because of a lack of comprehensive indexes. And I'm now going to say something about deeds and court records in Scotland. Those who, like me, have some Scottish ancestry should certainly search the legal records held in the National Repositories in Edinburgh, which are extensive and actually, as far as the deeds are concerned, more complete than in England. And this is partly because there were elements of feudalism which survived in Scots law until 2004, but also because inheritance in Scotland was historically very circumscribed, with the law largely dictating which relations could inherit what. So the two most important sources for genealogists looking into Scottish ancestors in this respect are the Register of Sazins, which record land transactions very consistently over the centuries, and also the Retours of Heirs, which record inheritance passing from one generation to another. And both of these records, to a certain extent, at least the abstracts, are searchable online. So it's possible to start looking at these records online, even if eventually it might be necessary to actually look at the original document in order to find the information that is being sought. And it's also worth noting that the records of the Court of Session in Scotland, of course, Scotland has a different legal system from England, so you'll be looking at different courts, but the records of the Court of Session, which dealt with civil disputes, could be searched for the same kind of information which is found in English Chancery records. So I hope that this has given you a helpful overview of how deeds and civil court records can be used by genealogists. I think that the legal side of genealogy is often quite sensationalized. Many of us tend to look perhaps more at the criminal records than at the civil ones, understandably intrigued by the possibility that an ancestor might have been tried for a crime or perhaps imprisoned or transported. But as I've attempted to show in this talk, the deeds and the civil records also contain rich details, which, even if they're not quite as sensational all the time, can in the long run be more beneficial for genealogical research. It is hard work to find the relevant information a lot of the time, but once it is found, the information contained in the deeds and civil records can really enrich our understanding of our ancestors' lives and often resolve some of the problems that we might call brick walls in the process. So in the handout accompanying this talk, which you should be able to download, I've put relevant links to sources which I hope are helpful and will also allow you to perhaps see some images of some of these records that I haven't been able to show in my presentation. I am very happy to answer questions in the time remaining. In this slide, you can see my contact information. You can contact me through my website, which gives details of my work as a professional genealogist. And I also have social media accounts on Facebook and X, which you can see there. And finally, if you'd like to give some feedback about this talk, you can do so in the app using the instructions which you can see in this slide. So thank you very much for listening to this talk. I hope that you found it helpful and I look forward to your questions. Thank you.
You need to come off mute, Jocelyn. I'm still not hearing any sound coming through your mic. Are you hearing anything from Jocelyn, Nicholas?
I'm afraid I'm not hearing Jocelyn at the moment.
Okay. Well, yeah, I'm gonna get Kathy here and bring her on stage.
Okay, sorry about that. Joss, we're not totally sure what's happening, but if it's okay, I'll jump in with the questions. So Nicholas Phyllis asks, if an ancestor in the 1700s was knighted in the Irish dependency of England and was the holder of considerable grants, lands, and properties in Ireland under the British Crown, would the lands have a deed, and where could that be found?
So records relating to land in Ireland are very likely to be in Ireland itself. Unfortunately, many of the records that related to land transactions and legal proceedings in Ireland were destroyed when there was a fire at the Public Record Office in Dublin in the 1920s. So it is rather more difficult to find that information in Ireland, as I understand it, although I have to say I'm much more of a specialist in the research in England and Wales. So I do believe that there are ways around that. So I would, in those circumstances, I would certainly encourage you to see what is available at the archives in Dublin. There has been recently a massive effort to reconstruct many of the materials that were lost from the Public Record Office, and of course there are archives throughout Ireland in particular localities where those kinds of deeds might be found. So it's worth looking at what archives are in the particular part of Ireland where this ancestor owned land and seeing whether they hold deeds. It's even possible that some of them might be in private hands, but certainly it's worth searching for those deeds in both the national and the local repositories in Ireland in a similar way to the manner that I've described in relation to English deeds.
Okay, great, thank you. Amy Scholes asks, are deeds recorded the same way as in America?
That's a very interesting question. I'm afraid that I don't have an enormous amount of experience of looking at American deeds. I think that sometimes the American land records, as they're often known in particular states, diverge quite a lot from English deeds because there are a lot of land grants in America at a certain stage which were done in a different way from the English deeds. But I certainly think that there are many similarities, particularly in the earlier deeds in America, because often they were being drawn up by lawyers who had been trained in England. And it's also worth noting that you may well find a lot of information concerning American land transactions in the Chancery records in the early days, because some of those estates which involved property in America could, if there was a dispute about inheritance, that could possibly have been disputed in the Court of Chancery in London. So I think that you will find many similarities with the earlier American deeds, particularly before American independence and perhaps to a certain extent after it as well. But I think as time went on, the legal system diverged to a certain degree. So although there are many commonalities, one certainly shouldn't assume that that all of the things that I've said in relation to English deeds apply to America, because although the legal systems have very much common roots, within America you will find divergence between the different states and obviously the legal systems from England. So although I think there are probably many interesting points of comparison, they're not going to be exactly the same.
Okay, thank you. This one isn't directly a question, but there are multiple people who have expressed their appreciation for how useful the handout is that was provided. So
I'm very glad to hear that.
That's probably something to give feedback on for this session as well.
Yes, it's good to hear that the handout is helpful. A lot of the links that I've given are to the online guides which are produced by the National Archives in London, and which I think are a very good starting point for investigating some of these records. And there's also a website that is attached to the University of Nottingham in England, which gives some really interesting and useful examples of the different deeds that I've described. So if you're interested in pursuing this further, I'd certainly encourage you to look at those things.
Okay, great. Now, this was kind of a general question from several people. It sounds like a lot of these records are not available online, but are there some that are viewable and searchable online?
I think that for many of the deeds, there should be a catalogue entry, which, although it's unlikely to show you an image of the actual deed or indeed a transcription, often the archives, particularly the county archives in England, have catalogued collections of deeds so extensively that you can find in those a lot of information, and obviously you would need to confirm it by looking at the actual deed. But so although I said at the beginning that this is a kind of research that you can't to a large extent do online, there is a lot that you can do online with the online catalogues. Now, there are some digitized records, legal records, on a very good website called the Anglo-American Legal Tradition, but those tend very much to be from the medieval period. So if you're doing medieval genealogy in England, then it's certainly worth investigating that. But I think for most of us, those digitized records are a bit too early. So often it is a case of either trying to access the documents directly or ordering copies from the archives where possible. But certainly there's a lot that you can start doing online. I would, however, say that it's very difficult to avoid actual archival research with these kind of records.
That makes sense. Thank you. Barbara Boucher-Coney asks, where would I look for divorce papers for a couple living in Chatham, Kent, England, about 1830s?
So divorce was relatively rare in England before the middle of the 19th century. You could have marriages annulled in the church courts at Doctors' Commons. So there are those cases were often reported in the newspapers of the time because they were fairly unusual. So even though the extent to which they survive in the papers in the archives, I think, is quite limited. There may be reports of divorces in the newspapers. If people were very wealthy, they could get divorced by an act of parliament, and then it would be debated in the House of Lords. So there would certainly be records of that in the proceedings of Parliament, in the journals of the House of Lords. So I think that for the 1830s, probably it's the newspapers and the printed press, and then possibly seeing if there might be any records in the National Archives by searching the people's names or in a local archive. But after the 1850s, the divorce procedure is changed a lot in England, and you can look at divorce papers on Ancestry. Those have been digitized from, if I remember rightly, about the 1850s until about 1914. So I hope that answers your question to a certain degree.
That sounded helpful to me. We're running short on time. We have about 2 minutes left. Do you want to try one more question or just wrap up?
Well, if there's a really short one that I can answer quickly, then I'm happy to answer another.
Let's see. Where do I look for writers of the Signet other than Signet Library? I have several of these in my family.
So that would be relating to Scottish lawyers. I would certainly encourage you to look at the records in the National Records of Scotland or the local archives for the part of Scotland where that particular person came from. And there may well also be published sources relating to lawyers in Scotland. So hopefully that gives you a few places to look.
Okay. Great. We have about 1 minute, so I think I'll just give it to you to wrap up, Nicholas.
Well, thank you very much to everyone for listening to this talk, and for Family Search for hosting it. It's been a great pleasure to share my thoughts about this topic. I hope that what I've said has been helpful, and I hope that the handouts are helpful to you as well. And do have a look at my website, drnicholasdixon.com, if you're interested in what I do as a professional genealogist. And I hope that you enjoy the rest of RootsTech. Thank you very much.
Thank you.